My name is Sarah Fahadi and my group partner is Addie Rose. We went to the magistrate court a couple weeks ago and we went to a hearing about a lady named Rachel Wallish who was convicted of drink driving in mid-January of 2024. Rachel had lunch with her family during her lunch break. She works at the Department of Maritime Safety Authority. A planned lunch with her close family had ended up with her sister telling her about upsetting news about her niece that had her very emotional. Before she had arrived to lunch, her brother had ordered a bottle of wine for the table due to her being emotional over the news of her niece, and she started drinking wine as a coping mechanism, which after on in the case had been found to be a common theme throughout her life. After dinner, she went back to work at approximately 1:30 p.m. She did not drive on her way back to the office as the restaurant was within walking distance to her workplace. When her work shift was done for the day, she had decided that she was okay enough to drive and the alcohol in her system would not affect her driving skills. As her office was on Mort Street, she exited the garage to turn onto the street where right outside was a random breath testing. Her breath test came back positive with a reading of 0.125, which was over the legal limit for a full driver's license holder. Her charge was a level 3 offense, in accordance with the Road Safety, Alcohol and Drug ACT Section 5. After getting charged, her license was suspended until her court date. In between getting charged, Rachel had been on good behavior and was attending both therapy as well as a drink driving program. During the case, she pleaded guilty and submitted 3 pieces of evidence to back up her own case. That was, she had never done that before. What she submitted was 2 character statements. One was from her mother and the other was from a family friend, as well as a certificate from the 2-day drink driving prevention program that she had attended. However, all what was submitted was pretty much not used at all, as her lawyer's statement was, and her driving history was looked at, which really helped in getting her judgment of her license back. Rachel lives alone in her flat in Lynham. During the COVID lockdown, she depended on alcohol as a cope with stresses in her life. Due to her drunk driving, she lost her driving license. Having her license was important to her as she was her mother's primary caregiver. She would visit her mother every day to help her with groceries and to take care of her.
So, after looking at all of the justice parties that were involved in the proceeding in itself, the most interesting member of the court that we both have found was the defendant's lawyer, that being Rachel's. Rachel's lawyer and how she carried herself in comparison to the plaintiff's lawyer was way more authoritative and clear cut in what she had to say, and overall was just more prepared, which, as a lawyer, is a key aspect and a key skill that you do need, just preparation overall. She was very direct in what questions that she had or the matters that she wanted to address. She never stumbled. She always had a answer for a question that could potentially be asked. So there were other mannerisms and overall just small touches that were very noticeable during the entire proceeding that we both paid close attention to and found overall very admiring. As it was Magistrates Court 3 that we went to on the day, we watched and we cycled through a couple other proceedings as well. And overall, with those lawyers that were pleading their cases for their proceedings, whether it would just be a motion to dismiss or filing for a motion to be dismissed, the mannerisms that we picked up for the defendant's lawyer were qualities that were not exactly shown by other lawyers, whether they were the plaintiffs or the defendants. The small qualities that aren't even small, but the qualities that we found were such as how every time she addressed the judge, she would stand, which can be seen as quite minuscule, but if myself personally were a judge, I would definitely pick up on that small note, as almost every lawyer during that entire day, that entire session of proceedings, almost never really stood or paid attention to fixing their body to when they were talking and things of that. Another mannerism that we also found was for her closing statement. She brought out a piece of paper instead of a laptop or tablet, which, when watching the proceedings, I personally can't say that that is a typical thing that will happen when one is giving a closing statement, but seeing from the judges, just overall body language and facial expressions, she was quite pleased at the fact that she brought a physical piece of paper, which indicates that it's not really typical to be a part of the norm when most lawyers bring out their closing statements. And finally, this will get come as trivial, but she also knew how to control her volume when talking. So as the room was quite faint, because no one's really talking besides the judge, the plaintiff, and the defendant, and the lawyers, it was quite interesting to see how other lawyers were struggling to gauge the volume that they were talking. So, especially with the quietness of the room and the added fact of the microphones that are in courtrooms, it would be either people are speaking at a volume that is very low, which makes it hard to hear, which then I also, to pick up, the judge would have to ask a lot of, oh, could you repeat that? Oh, sorry, I didn't get to hear that. Could you repeat yourself? Or you have people who are very loud talkers. So that small mannerism that she did have was very noticeable for us. And for the most important part of a proceeding, the most important part of a proceeding that we both hold in high regard are the values and the core of justice principles that are being served fairly and equitably. So that would include fairness and impartiality, which is the idea that all proceedings, no matter what court, whether that is the children's, the magistrates, or the Supreme, have to be conducted with absolute fairness and impartiality. So all parties would have to be separate from their own personal biases or prejudices and hold them aside and only make decisions that are based on facts and that are also applicable by law. Another would be access to justice, which is essentially that any member of the public has access to the legal system. That means all parties are on the same and even playing field in access to participating in legal proceedings. That could include having interpreters if needed, as well as having all needed resources available to those that give the opportunity for effective self-counsel to be made. Another would be finality and enforcement, which would be the legal proceeding would have to be concluded, and then the judge's final ruling has been made, and the end result of whatever the ruling has been made has to be enforced on whatever party it has been given to. This helps both the law be upheld and establishes the concept of true closure of an actual case. So when enforcement is involved, it makes judgments from words that are theoretical into something that's practical and final. And due process, which is every individual that is involved in proceeding, is entitled to due process, which is a right to a fair and impartial trial. So due process would essentially take all of the aspects from the previously listed qualities and would all come into one to essentially make due process. And that means we come to the conclusion of today's presentation. Thank you so much for listening, and I hope you enjoy the rest of your day.